Hi guys, it's Kathy. I hope you're doing well. We made it to Monday. Oh, Monday. I hope you guys had a good week and ready to start a new week. So, I found out what almost all Pennsylvanians are finding out right about now. That we all need sun. When spring first hits and we go from, our winter clothes to our spring clothes, then we all find out, holy cow, we are pale. Pale. Very, very pale. But that's okay because it's going to get hot out soon. And we can go get some sun a little bit. We have an update on a case with Judge Frost. We're going to start with a new judge, I think. I don't know. I know I've seen her before, but I don't know if I showed everybody her before. Judge Lang. She's a pro tem, I think. I don't think she has her own court. I think she just does pro tem. But she could have her own court that she doesn't stream in Indiana. And Judge Clymer. Clymer? It's Clymer. Clymer or Clymer? Probably Clymer. We'll see him too. We'll do Judge Frost last because I love Judge Frost. I just do. But we're going to see a few doozies in this courtroom. Before we get to the one where is it contempt of court or is it mental health issues? I have a strong opinion one way, but I'm not going to say. Here we go. And yeah, I can see my feed is just not working. It's just not. Fixing it now.
Hey, Ryan.
State.
Is it a misdemeanor or is it a felony?
I think it's charged as a
Felony.
Ouch.
Yep.
Ready?
Yes.
Good morning, Your Honor.
Good morning.
In custody call, State of Indiana versus Amber Nicole Rhodes, 2508 F6 1065. Yeah, I'm going to give you the blue. Warrant was issued for failing to appear.
Morning, Ms. Rose.
Good morning, Your Honor.
So we are here. You had a warrant.
Yes, ma'am.
Let's see, that was on April 13th that you failed to come to court.
Yes, ma'am.
And back in November, there was a petition for revocation of bond. All right, State. What are you seeking today?
Judge, she failed to appear, so we're asking for a standard bond we posted.
And
Oh, if I could see Hamilton.
this is an
Oh,
F6,
my
so that would be
That would be
$750.
so cool.
Yes, ma'am.
And has a defendant, she previously posted?
Obviously, that didn't do us any good because she still failed to appear with the previous posted bond.
And when this warrant was issued, was there counsel?
I believe we were at status of counsel hearing to see
Okay.
if she's going to obtain counsel.
All right, Ms. Rhodes. So, first of all, you did post a bond initially, correct?
No, ma'am. I was OR'd. And then what happened is my car broke down and I called ahead and they set it out for another week and I was still stranded and couldn't get back. But no excuse. I did call ahead and they did try to give me an extra week and then it was the following Friday and I wasn't able to get back still.
So that was November 7th. There was a failure to appear. And then again on November 24th.
Yes.
So, when that happens, it just doesn't go away.
No, I know. I was trying, I spent my time trying to get back. I was stranded. I have no family left. My mom died and it's just been a struggle.
There were like 5 months.
Yes, no, I understand. I understand.
Okay. All right. So bond is set at 750, and then do you intend on hiring a counsel?
I don't have money to hire counsel.
Wait, will you raise your right hand, please?
Hey, Brian.
Swear to tell the truth, the whole truth, and nothing but the truth.
I do.
All right. Were you working when you were arrested on this?
No.
When's the last time you worked?
2 years ago.
Okay. And so how do you support yourself?
I really don't. I was kind of homeless. Like I said, my mom helped me and then she passed away. I was helping her and I really been kind of homeless. So I've been going to
Where have you been? So where do you live? You said you're homeless.
Yeah.
Where have you been residing?
I just sleep wherever I can. A friend will let me stay. If not, I'll sleep in a tent. I've been all over.
Okay. Do you have a vehicle, a car, anything?
No, not right now.
Do you have any bank accounts, savings, checking?
No, ma'am.
Any other sort?
In her defense, her car broke down, which is why she failed to appear for 9 months, because her car broke down.
Of income or funds that come in for you?
No.
All right, I'll appoint a public defender to represent you. And how far will we set this usually?
You
Pardon?
phone number.
Do you have a phone number?
219
It was an excellent one.
229 3055.
All right, and how far out for status? 30?
45 of the meeting.
45, so it's at the middle of June. June 8th. So your next court date is June 8th. Public defender will be in contact with you. And
I guess there's a nice should be better.
is there an address where you can get mail?
Let's see.
All right, June 8th.
Yeah.
Thank you.
Thank you.
All right, next case.
State of Indiana versus Jordan Johnson. 2109 F6 1301. Fifth petition to revoke suspended sentence. I believe it's the initial hearing on that.
Your Honor, that's Jada Johnson.
I don't know the Jordan.
Yeah, Jayla Johnson.
Jada.
Judge Pata.
Okay. All right. So, Ms. Johnson, we are here today on a fifth amended petition for violation of probation. And
Just so you know, that means she's violated 6 times, because this is the 5th amended petition to amend. So she has already violated 6 times. I wonder what will happen to her.
so that petition alleges. No, what does it allege?
The fifth petition, Your Honor, that's been filed in this case specifically states
Let's see.
Hi, Salty.
I've got it, counsel.
You got it?
Yes.
Okay.
All right, so this petition to revoke, the fifth petition for revocation of suspended sentence, alleges that you were placed on probation as a result of a sentence imposed by this court on December 13th, 2022, and that you were in violation. The allegation is of condition number 1, that you refrained from violating any law, federal, state, or local, and that you allegedly committed 2 counts of the offense of possession of cocaine, level 6 felony, and possession of paraphernalia, a class C misdemeanor, on or about the 12th day of December 2025 in Porter County, under cause number 406005-2512 F61345. Also, that you were in violation of condition number 7, that you shall not use, purchase, or possess illegal drugs or illegally obtained prescriptions, and that you allegedly possess cocaine on or about the 12th day of December 2025. and that you allegedly violated condition number 4, that you report for probation appointments as directed by the probation department, and that you failed to report to probation as directed.
Yeah, but what, guys, seriously, what are the chances they told her she had to do all that in the first 4 petitions to amend? There's no way she already knew she wasn't supposed to do it, any of that.
And the
Yes.
probation has filed a recommendation. And state your position on that.
Judge, it's the 5th petition. She was put on probation, and there's been 5 petitions filed beforehand. We're asking for a $1,500 cash bond.
All right, so Ms. Johnson, you are entitled to a hearing on this petition. You understand that?
Yes.
And if there was a hearing, the state would have to prove by a preponderance of the evidence that you did indeed violate your probation as it says in this petition. You understand that?
Yes, ma'am.
You'd have the right to call witnesses, see, hear, question, cross-examine any witnesses called by the state. You understand that as well?
Yes, ma'am.
And the possible sentences includes an up to the amount left of your suspended sentence in the LaPorte County Jail or Department of Corrections. Do you understand that?
Yes, ma'am.
You're also entitled to counsel for representation of counsel if you choose in this case as well. You understand that?
Yes, ma'am.
All right, so I'm going to set a bond at, let's see.
I had a question.
Yes.
Can I say something? I have a
Let me
certificate.
just say one thing. I would just advise you not to talk about the facts because we're on the record. Court reporters taking down everything we say. So that could be used against you. I just want to make sure you understand that before you say anything about the case.
Yeah, I just had a certificate here. I graduated the chemical addiction program at Porter County. That was 3 months. And then I graduated life skills also. So I wasn't just doing like how I did my time there. I feel like it affected like my my life path or whatever that I'm on and stuff like that. And I also have a what's it called? Thing into the YWCA, an acceptance letter. I emailed my lawyer, Paycheck and Rodriguez. And I've had a bed there that my caseworker, Allison, knows about. She said she could take me if that was the option.
Okay, so those are all things that you need to communicate to your lawyer. Is there currently a counsel in this case? Probably
I didn't
not.
see that anyone entered on the revocation.
Okay, so do you plan on hiring someone to represent you in this matter?
No, ma'am.
And why is that?
Because I don't have the money to.
All right, so you said Mr. Paycheck represented you at one point, so you hired him?
Yeah. Yes.
And then Mr. Rodriguez also represented you at
Yes.
some point? And was that as a public defender, or did you hire him as well?
Public defender.
Representation, Your Honor.
Okay. All right, and Mr. Rodriguez, was that most
This is a
recent?
circuit court.
Ah,
Might go to Watterson now, so I'm texting him right now, so he's
Okay.
aware she's been picked up.
all right. Would you raise your right hand, please?
Yes.
Swear to tell the truth, the whole truth, and nothing but the truth.
Yes, ma'am.
Okay, were you, when's the last time that you were employed?
It's been 4 months at least.
Okay, and where were you working then?
Okay, but it's been longer than 4 months, but I mean, just off of like I've been locked up for that long. So really, I would say about like 6 at least, and I was cleaning houses.
So, before you were picked up, where were you living?
At my Nana's house at 907 Virginia Avenue, LaPorte, Indiana.
All right, were you paying any rent?
No,
And do you have any bank accounts, savings, or checking?
no, ma'am.
And do you have any kind of car or vehicle that you want?
I have a car.
Okay, what kind of car is that?
It's a 2006. I don't even know what it's called, honestly, but it's just like a broken down old car.
Bobby's on a streak on Twitch. Good job, Bobby.
Okay,
Gets me to A to B.
I'm sorry?
It gets me from A to B, place A to B.
But you don't know what kind of car it is?
I honestly can't. It's like an Altima. I want to say it's an Altima or something.
Okay, are you making payments or do you own that car?
I own that car.
All right, I'm going to appoint the public defender to represent you and set bond at $1,500 cash. And then we need another date. So public defender, how long? 45?
Yeah.
All right, so we'll set this for June 15th.
Okay, thank you.
What else was it? I think she said no.
Could you give us your address again? There's a little discrepancy there.
Yeah, 907.
Okay. All right, thank you.
Or he should add, I want to shoot baby.
State of Indiana versus Brooklyn Grace Temple, 2604 CM 841. Initial hearing, Your Honor.
All right, good morning, Ms. Temple. You're here today for an initial hearing. First of all, would you state your complete name?
Brooklyn Grace Temple.
Okay, you're gonna have to speak up a little bit. Okay, say your name again, please.
Brooklyn Grace Temple.
Right, you have to speak up because the court reporter has to get everything down and the court has to be able to hear you. So let's try that again. Could you just please speak up?
Brooklyn Grace Temple.
Perfect. And do you have the ability to read and understand the English language?
Yes.
What is your age?
23.
Okay, you need to speak up again or get closer to the microphone.
23.
Okay, and what's your address?
19 West 46902.
Okay, what,
46929.
but what town is that?
Flora.
Florin?
Flora.
Yep.
Flora. And how far did you go in school? What grade?
12.
Okay, did you graduate?
Kind of.
Kind of. Okay, so either you get that certificate or you don't. So did you graduate? Did you get the diploma from high school? Or GED or whatever?
Probably.
Probably. Okay. Are you now under the influence of any medication, drug, or alcohol?
Nope.
Is that a no?
Nope.
No, not no. Is it a no?
Nope.
I can't hear you very well, and I can't tell if that's a nope or a no, but it needs to be a no. So I'm going to ask you again, are you now under the influence of any medication, drug, or alcohol?
No.
Today, could you advise the defendant of the statute, charge, and possible penalties?
Your Honor, she is charged by way of information that alleges that on April 10, 2026, in LaPorte County, state of Indiana, the defendant unlawfully, knowingly, or intentionally refused to provide her name, address, date of birth, or driver's license if in possession. She refused to identify or comply with the officers on a legal traffic stop to a law enforcement officer who has the lawfully stopped the individual for an infraction or ordinance violation, commits a Class C misdemeanor. Class C misdemeanor is 60 days in LaPorte County Jail and a $500 fine. She is also charged with, on that same date and time, with unlawfully, knowingly, or intentionally did operate a motor vehicle and recklessly drove at such an unreasonable high or low rate of speed as to endanger the safety or property of others or to block the flow of traffic. That is a Class C misdemeanor. Class C misdemeanor, again, is 60 days in LaPorte County Jail and a $500 fine. Those are the two charges that she's currently facing.
Counsel, does the defendant have any previous convictions? All right, while the state's looking at that, Ms. Temple, do you understand the charges against you and the possible penalties?
Temple.
She's.
Temple.
Ms. Temple?
Brooklyn.
I need to go back to
Your
that.
Honor, if I may, I'm not sure
Yes.
I'm not sure if she's,
Coherent.
mentally all there.
Okay, I understood.
Good.
Is she asleep?
No, she's not sleeping.
Okay.
Your Honor, if it may please the court. What is her middle name? Grace.
Brooklyn Grace Temple.
I have a cause number 80C01-2409. G as in George, U as an umbrella, 19.
Okay. Is she currently under an active guardianship? Can you tell that?
Appears to be. No, I'm sorry, hold on. There's a motion to terminate. Terminated 3/17/25.
3/17/25, so
Yes, ma'am.
a year ago-ish.
But was the subject of a GU.
Say for tomorrow, I see if she can say.
This afternoon.
Or
Tuesday.
with.
To magistrate.
She probably make today.
No, they do it.
Well, what do you say?
Because
What do you say?
Because clearly we're not able to hold this initial hearing, so then we can move the initial hearing for tomorrow.
Different tomorrow.
I don't know, if this is just like a mental thing, then it's not gonna be any different.
Or
If she's sleeping, I don't know. If she's sleeping, that would be different, but.
All right, Ms. Temple? Ms. Temple, can you hear me?
Brooklyn.
What you said Friday.
Hey,
She was in jail.
I,
Set up her phone, so she's.
Your Honor, should we adjourn this to the 12:45 court call?
or tomorrow in order to get it.
Tomorrow?
there. But we're gonna set it for tomorrow, 12:45, but isn't there gonna be a senior judge there?
That's why I was thinking today, but, because he's here today, but it's fine. That's why I was saying,
I'm gonna.
Gotta participate in court.
Try a taser.
Jail, is she, I understand there might be a mental health issue, but is she physically okay?
Yes.
yes, Your Honor, she walked up here just fine.
Okay, all right, so would we be able to, get her back here in court at 12:45?
Probably not today. Can we try tomorrow?
All right, we'll say it tomorrow. I'm gonna appoint the public defender to represent her.
Sure.
Can we get a public defender in that fast?
no.
Well, if this is an emergency, I can order it. That's why they pay me the big money.
It's true.
All right, I'm ordering a public defender to appear.
There's one that is always in magistrate's court anyway, so
All right.
he'll be able to step in regardless.
All right, so public defender is appointed. Ms. Temple needs some representation so we can move forward and make sure the right thing happens. All right, so Ms. Temple, I would imagine you can hear me. I know you're maybe not understanding everything we're going to do today, but you're going to come back to court tomorrow, be a different judge, and there's going to be a public defender to represent you, and the court will attempt to determine what the best step forward is, but let the record show that the initial hearing was not completed due to the defendant's inability to participate. All right, tomorrow, 12:45.
Judge Greta something, I cannot remember her last name right now. I lost it. But Judge Greta had her the next day and did not stream. So I do not know what happens to her the next day. I don't know. I would say contempt. Contempt or mental health. Which one is it, guys? Hi, Crystal.
We're gonna go back downstairs.
Your Honor, if you could just give me a minute.
Sure.
2604 F6 394. Initial hearing. We would also ask for a no contact order.
All right, Mr. Moore, you're here today for an initial hearing. Would you state your complete name?
Stephen Moore.
You have the ability to read and understand the English language?
Yeah,
Is that a yes?
yes, ma'am.
And what is your age
38.
and your address?
You said that, so what?
21st, right?
Your address?
I'm pretty much homeless right now.
Can I ask now? So she's in a.
Do you have an address that you can receive mail?
She's the hoe.
Pardon?
She's the hoe
I think it's
on Franklin Street.
1201 Franklin.
What's that?
Is it 1201 Franklin?
1201 Franklin? Does that sound right?
I think
Yes, ma'am.
Okay. How far did you go in school? What grade?
You say what?
How far did you go in school? What grade?
Oh, 10th grade.
Are you now under the influence of any medication, drug, or alcohol?
No, ma'am.
State, could you apprise the defendant of the charged statute and possible penalties?
He is charged by way of information that alleges that on April 10, 2026, in LaPorte County, state of Indiana, the defendant unlawfully, knowingly, or intentionally, in a rude, insolent, or angry manner, did touch a family or household member by pulling Shannon Moore's hair and dragging her across the floor. That is a Class A misdemeanor. Class A misdemeanor is 1 year in LaPorte County Jail and a $5,000 fine. That charge was enhanced due to having a previous conviction for a battery offense, which makes it a level 6 felony. Level 6 felony is 6 months to 2.5 years. Indiana Department of Corrections, $10,000 fine with a presumptive sentence of 1 year. He is also charged with, on that same date and time, with unlawfully, knowingly, or intentionally, while not having a contractual interest, did enter the dwelling of another person, and refused to leave when was told multiple times to leave by the manager, which was a Shannon Gerard. That is a Class A misdemeanor. Class A misdemeanor is 1 year in LaPorte County Jail and a $5,000 fine. And that charge also
He has one question that scares me. You'll see.
reflect he did not have a contractual interest and refused to leave that property of another person after being asked to leave by that other person's agent. That's also a Class A misdemeanor. He is also charged with, on that same date and time, with unlawfully, knowingly, and intentionally or recklessly did danger to face property of another person by damaging the door to the women's restroom without their consent. That is a Class B misdemeanor. Class B misdemeanor is 180 days in LaPorte County Jail and a $1,000 fine. He is
I don't think this was his girlfriend.
also charged with, on that same date and time, with unlawfully, knowingly, or intentionally or recklessly engaged in fighting or tumultuous conduct by kicking in a bathroom door and making threats and dragging Shannon Moore by the hair out of the restroom at the Dairy Queen, putting employees in fear. That's a Class B misdemeanor. Class B misdemeanor is 180 days
I think she was a worker at Dairy Queen.
LaPorte County Jail and a $1,000 fine. Those are all the charges, Judge. We would ask for a no contact order.
Do you understand the charges
I could be
against you
wrong.
and the possible penalties?
Yes, Your Honor, but none of the, I don't understand like why it's saying I did that because I did not do.
All right, so let me just advise you of one thing, Mr. Moore. That would be not to talk about the facts of the case. Right now, we're just making sure you understand what you're charged with. Everything is being taken down by the court reporter. That means it could be used against you by the state later. I do want to ask you, though, did you hear the tape of telling you what your constitutional rights are?
Yeah.
Do you have any questions about that?
I would try.
Not exactly. Now, I just got one question. Did the state pick this up or were these charges pressed against me?
The state is the one that either decides or to bring charges or not bring charges. So the states file them, it's under their signature, and that's how the cases come to
I feel like if she would have answered differently, retaliation was in his future.
court.
So the state picked it up.
Yeah.
Okay.
There will be a protective order issued at this time, which means you can have no contact with the alleged victim. in any way, whether in person, by phone, going to where you know them to be no contact at all. And that's while you're in the jail and when you get out of the jail.
Okay.
Okay, we need to set a bond.
Judge, if I may,
Yes.
he has 2 prior pending cases, 2603 CM 501, resisting law enforcement as a named misdemeanor, filed on March 5, 2026. I have 2603 F6310 filed March 19, 2026, possession of methamphetamines as an F6 felony and possession of paraphernalia as a Class C misdemeanor. And then about 3 weeks later, we have these charges. We're looking at $1,000 cash bond.
There's previously posted bond, obviously, in the other 2 cases.
No. I OR'd, I believe.
He hasn't, he hasn't, Rodriguez.
Bobby's too pretty for jail.
Okay.
No.
All right, we'll set your bond at $1,000 cash. It's my understanding you're represented on the other 2 cases by the public defender. I'll appoint the public defender to represent you on this case as well. And it's continued to, what date? May 12th at 12:45.
Your Honor, if I may, Mr. Moore is on pretrial services. In his other matters, did you want him to remain on pretrial services?
Well, if he is able to bond out, then he would remain on pretrial services.
Okay.
Thank you.
State of Indiana versus Robert J. Core, 2604 CM 845.
There.
Judge, on the last one, we have a no contact order in place.
Yes.
Okay. We would ask for no contact order on this one here also, and we'd like to be heard on the issue of
Oh,
bond.
this guy.
Follow up in writing with that, counsel? The no contact order. Okay, thank you. All right, I'm sorry, is this an initial as well?
Yes, ma'am.
All right, Mr. Core, would you state your complete name, please?
Robert J. Core,
Do you have the ability to read and understand the English language?
I do.
What is your age
78,
and your address?
my house was stolen from me, so I don't know what my address is.
Okay, do you have an address where you can receive mail?
Some woman is living in my house. She got a quick claim deed. She has the house. I don't want any mail going there.
Okay, well, that's fine. I just need to know if there is an address where you can receive mail.
I do have a P.O. box.
Okay, and what is that? All right.
You see how the you see the little V in his collar? I wouldn't be able to handle that. You see how they have the orange on the white part, so we have the orange stripes and the white stripes going across, but on the V, the orange is beside the white at that one part. I wouldn't be able to handle that, so I don't think I should go to jail. I would say that to the judge. Look, I can't wear that shirt. It's just not right. I can't do it.
Right. Let's see. How far did you go in school? What grade?
1 year of college.
And have you ever served in the military?
6 years in the National Guard.
And when was that?
During the riots of 68.
Okay. Are you now under the influence of any medication, drug, or alcohol?
None.
State, could you apprise the defendant of the statute, charges, and possible penalties?
He is charged by way of information that alleges that on April 12, 2026, LaPorte County, state of Indiana, the defendant unlawfully, knowingly, or intentionally did touch the person of the Kelly Acton in a rude, insolent, or angry manner by smacking her in the face. That is a Class B misdemeanor. The B misdemeanor is 180 days LaPorte County Jail, $1,000 fine. That charge was enhanced due to the result of bodily injuries occurring, redness to the right side of her face. That made it a Class A misdemeanor. Class A misdemeanor is 1 year LaPorte County Jail and a $5,000 fine.
Do you understand the nature of the charges against you and the possible penalties?
Yes, I do, and I want to deny I never touched her. I let her live with me for free.
So let me just caution you, today is not to talk about the facts, and as a matter of fact, my caution to you is that everything's being taken down by the court reporter, so it could be used against you by the state. So I just need today, the court does, to make sure you understand what you're charged with and what the possible penalties are. Also, did you hear the recording of your rights that was played to you earlier?
Recording to my wife.
Of your constitutional rights. I'm sorry, I didn't speak up very well. Your
Yes,
constitutional rights.
yes.
Okay, you have any questions about that?
I didn't do anything wrong, ma'am, and that's all I can say.
I understand that's what you're saying, but right now what I need to know is that recording of your constitutional rights as a defendant in this courtroom, do you have any questions about that?
Well, I would like to take a lie detector test to prove it.
Okay, but again, whether it's true or false, the allegations, right now I need to know, did you hear those constitutional rights, what your rights are, and do you have any questions about that?
I heard them.
Okay, any questions
Not,
about that, just about your rights?
no.
Okay, regarding the issue of bond, state,
Judge, I'll leave it to your discretion.
okay. Defendant has,
Okay,
Penny-
lazy, and it pisses me off. Sir, you filed a charge against this man. You brought the charge against this man saying he did something wrong. You don't care what the bond is? If you don't care, why did you file a charge against this man?
cases,
He's getting sentenced on 427 in a trial that we had a couple weeks ago that
He failed to appear for his trial.
Yeah, he didn't appear. So there was a warrant. He was just bonded out of jail a couple weeks ago for failing to appear for his trial.
he failed to appear to his side.
They tell you if you do not appear for your trial, they are going to hold the trial anyway. And they did.
Yeah.
Pardon?
I'm just clarifying, the defendant failed to appear for his trial. He was tried in absentia?
We tried him in absentia.
He was picked up a couple weeks ago and he just bonded out for $600.
All right, the court's gonna set no bond and continue this to 427. There's sentencing at that time, the issue of bond can be addressed at that time as well. Does he have counsel in that?
He did. Trying to think who it was.
Andy,
Dallas Coleman, I believe.
Okay, well, we can address that, but I'm gonna continue the issue of bond until, the sentencing date. All right, Mr. Kaur, so you're back in on April 27th for sentencing. There was,
No contact order?
not yet. Yeah. And state, you said something about a no contact order?
It's a battery charge, Your Honor, standard requests.
Okay. All right, so there'll be a no contact order. So that means you cannot contact the alleged victim in this case in any way while either you're in the jail or if you're released from the jail. You understand that? You can't call, you can't look, you can't go to their house, you can't go anywhere you think they're going to be. No contact at all. So you understand that, correct?
I do, but this woman has done a quick claim deed on my house. She told me she was going to buy it. She never came up with the money.
Okay, so you need to make sure your attorney knows all that and you'll be back in court on the
He
27th.
was pro se in his trial. I just looked.
Oh, okay.
He's pro se in his
So
trial.
do I have a bond, Your Honor?
No, I've continued that to April 27th when you're going to be in court for sentencing. And if the court feels that you need a public defender at that time, they can address that issue. All right, thank you.
Thank you.
So when they had the
State of
trial
Indiana
without him,
versus Jess.
when they had the trial without him, he was pro se to begin with. There was no case on his side at all. Nothing. The prosecution just did their thing, and then the judge rolled, or jury. I don't know if they said jury trial or bench trial. But all right, that judge had a day, and I don't know if she has her own. It says right there, Senior Judge Lang. I knew it was Judge Lang. I don't know. I don't know if she has her own bench or if she just does pro tem now. All right, let's go to Clymer.
State would call Camilla Green. This is State of Indiana versus Camilla Green, 64D02 2604 F3 3981. Defendant appears via Zoom from the Porter County Jail with Attorney Elwood here in the courtroom for purposes of this bond hearing. State by Deputy Prosecutor Poulos. We are set today for initial hearing.
And the signed one is in the computer too. In addition. Could you raise your right hand, please? Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
What is your name?
Graham.
How old are you?
20.
Do you understand English?
Yes, sir.
Are you under the influence of any drug or alcohol?
No, sir.
Do you have any mental or emotional disability?
No, sir.
If there's ever a time where you can't hear or understand anything, will you let me know, please?
Yes, sir.
The prosecutor is going to advise you of the charges that have been filed against you and the potential penalties if you're convicted of either or any of those charges, and then we'll discuss the no contact order that you've signed.
Yes, sir.
Thank you, Judge. She's been charged with robbery causing injury as a level 3 felony. The charging information states that on or about April 9th of 2026 in Porter County, Indiana, Camilla Sandrina Danae Green did knowingly or intentionally commit robberies defined as knowingly taking property from another person or their presence by force, threat of force, or by placing any person in fear and armed with a deadly weapon or causing bodily injury. A level 3 felony carries a potential prison sentence ranging from 3 to 16 years with a fine of up to $10,000. Count 2 is battery as a level 6 felony. The charging information states that on or about April 9th of 2026 in Porter County, Indiana, Camilla Sandrina Danae Green did knowingly or intentionally touch Bradley Earnhardt in a rude, insolent, or angry manner and committed the offense that resulted in moderate bodily injury to the person. A level 6 felony carries a potential sentence of 1 year in jail and a fine of up to $5,000. She's also been charged with count 3, battery as a class A misdemeanor. The charging information states that on or about April 9th of 2026 in Porter County, Indiana, Camilla Sandrina Danae Green did knowingly or intentionally touch Ronald Dzinski in a rude, insolent, or angry manner, which resulted in bodily injury contrary to the appropriate Indiana code. The class A misdemeanor carries a potential sentence of 1 year in jail and a fine of up to $5,000. That's a sum of substance. Your Honor, I misspoke. A level 6 felony carries a potential sentence of 6 months to 2.5 years in jail and a fine of up to $10,000. That's a sum of substance, Your Honor.
Ms. Green, do you understand the allegations that have been filed against you?
Yes, sir.
Do you understand the potential penalties if you're convicted of either of those allegations?
Yes, sir.
And you were present when I advised Mr. Marinetti, the first defendant, of his rights. Is that correct?
Yes, sir.
You understand that the rights that apply to him also apply to you?
Yes, Your Honor.
Do you have any question at all about your constitutional rights?
No, sir.
I am entering not guilty pleas for you, reserving your right to a jury trial. Before we discuss bond, I have papers that indicate that you have signed 2 no contact orders in the Porter County Jail. Is that right?
Yes, sir.
I want to explain to you what the no contact orders mean. That means you're not to be where the protected people live or where they work. You're not to be with those people. Do you understand that?
Yes, sir.
Do you also understand that you're not to have any communication with them by internet, social media, email, phone? You're to have no contact at all with the protected people. Do you understand that?
Yes, sir.
Do you understand that if you violate the terms of the no contact order, that could result in a new charges being filed and your bond being revoked? Do you understand that as well?
Yes, sir.
We will now address bond.
Thank you, Judge. Ms. Green scored a 3 moderate on the IRAS score. She, as far as I can see, she has no other criminal history, Your Honor. However, looking at these charges, Your Honor, they are very serious in nature. She is accused of using a crowbar to beat up two other people, Your Honor. Given the seriousness of these charges, state would be requesting a $100,000 cash bond.
Ms. Green?
Can I say something?
Well, hold on. I just advise you, you have a right to remain silent. You have a lawyer who's here in court for you as soon as the camera turns back on the computer. But let me say this. First of all, I'm entering not guilty pleas for you. You don't have to. I'm reserving your right to a jury trial. You don't have to ask for that. And I'm going to appoint a lawyer if you cannot afford one. But we're not going to have a trial today. But if you want to tell me something, you can. But first, we want to hear from your lawyer because the state's asked for a $100,000 cash bond. It might make sense to let your lawyer speak for you first, and then you can tell me whatever you want. But you also have a right to remain silent as soon as our computer gets working. What happened? Do we want to try the other one? It was working earlier.
And that's what I'm saying, Judge. I was sitting there watching my computer work fine. But then as soon as I start my stream, oh no, there goes my YouTube live stream again, my feed. But it's fine. I fixed it, Judge. You can too.
All right, here we go. So, Ms. Green, the person seated in the left is your lawyer. Mr. Elwood.
Thank you, Judge. Ms. Green, is there an amount of bond that you can afford?
Did you say so?
Is there an amount of bond that you can afford?
Like 1,500, 2,000.
Judge, she scores a 3, moderate, no FTAs, no holds. As state said, no prior record. Certainly seems out of character. I'm sure there's the rest of the story here. I would ask the court to order a $1,500 cash only bond, supervision level 2, which is recommended.
I try to miss all pearls of wisdom.
Are there co-defendants that have been charged in other courts
Yes, Your Honor.
other than no contact orders? Do you know what the status of their cases are?
I do not, Your Honor. I mean, they should all be having their initial hearings, I'm assuming, this week.
Ms. Green, do you work?
Yes, sir.
Where do you work?
Mine is at Portage.
How much money do you make?
I get paid every week. I mean,
How much money do you get paid each week?
like 400, 500.
The probable cause affidavit indicates that the victim sustained significant injuries.
Yeah, because she got hit with a crowbar multiple times. So yeah, pretty bad injuries.
Part of the issue that the way the probable cause is written is it says that the four stole someone's blue iPhone and 3 house keys. So all 4 of them didn't keep it, probably. One of them did, probably, which may be the best person to have been charged with stealing a phone, arguably, unless it's a conspiracy to steal a phone. And additionally, the injuries are quite concerning. And from what I read, it appears that all 4 defendants participated in that. We lost your camera again. Oh, it's back. All right. All right. So it's kind of a quandary in that the injuries are significant, but.
Good morning. I'm Attorney Jason Jack. I'm going to be serving as Judge Pro Tem this morning. Sorry for keeping.
All right. But the defendant has no prior criminal history.
Thanks for the cheers, Monica. Thank you.
I set bond in the amount of $10,000 surety and $500 cash. The no contact orders will remain in place. Ms. Green, what I'm going to do is I'm going to set this matter for an attorney status conference on May 6th at 10 o'clock to determine whether you or your family have been able to hire a lawyer to represent you. Do you understand that?
Yes, sir.
So you have an attorney status conference May 6th at 10 o'clock, an omnibus change of plea hearing June 3rd at 10 o'clock, final pretrial July 15th at 10 o'clock, and jury selection August 17th at 1 o'clock. Did you hear those dates?
Yes, sir.
All right. I will see you May 6th at 10 o'clock.
Long, this is State of Indiana versus Joseph Long, 64D02-2604 F53896. Defendant appears via Zoom from the Porter County Jail with a...
But bribe me for what, Bobby? All I do is show court cases. I'm just gonna keep showing court cases.
Attorney Trafficante, also via Zoom, state by Deputy Prosecutor Poulos. We are set today for initial hearing.
Is the NCO signed? Mr. Long, please raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
What is your name?
Joseph Long.
Mr. Long, how old are you?
I'm 18 years of age.
Do you understand English?
Yes.
Are you under the influence of any drug or alcohol?
No, Your Honor.
Do you have any mental or emotional disability?
No.
If I had a guess, he's in Indiana. If I had a guess, either Elkhart or St. Joseph is my best guess.
No, sir.
If there's ever a time where you can't hear any of us, including Ms. Trafficante, will you let me know, please?
Yes, Your Honor.
The prosecutor is going to advise you of the charge that has been filed against you in this case and the potential penalty if you're convicted of that charge. So please listen carefully.
Thank you, Judge. Mr. Long has been charged with intimidation as a level 5 felony. The charging information states that on or about April 8th of 2026 in Porter County, Indiana, Joseph Long did knowingly or intentionally.
I was wrong. It's Porter County. And now that I look, it says right there, Porter County Jail. maybe I should learn to read.
Communicate a threat to Richard Gill with the intent that he be placed in fear and that threat will be carried out. And while committing it, the person draws it or uses a deadly weapon. A level 5 felony carries a potential sentence of 1 to 6 years in prison and a fine of up to $10,000. That's a sum and substance, Your Honor.
Mr. Long, do you understand what the allegation is against you?
Yes, Your Honor.
Do you understand the potential penalty if you're convicted of that allegation?
Yes, Your Honor.
You have the following constitutional rights. You have the right to a public and speedy trial. Do you understand that?
Yes, sir.
Your trial could be conducted in front of 12 jurors or me. Do you understand that?
Yes, Your Honor.
You are presumed not guilty. The state must prove you guilty beyond a reasonable doubt. Do you understand that?
Yes, Your Honor.
You have the right to face and cross-examine every witness. Do you understand that?
Yes, sir.
You have the right to have me issue subpoenas to have witnesses testify for you. Do you understand that?
Yes, Your Honor.
You have the right to remain silent. You can never be forced to testify against yourself. Do you understand that?
Yes, sir.
You have the right to an attorney. And although you have Ms. Traficante, if you cannot afford an attorney, I will appoint one at no charge to you. Do you understand that?
Understood, Your Honor.
I am entering a not guilty plea and reserving your right to have a jury trial and ordering the state to produce discovery, including your criminal history, if any, to Ms. Traficante, which may even have already happened. But before we address bond, there's a couple things we're going to address. The first of all is a no contact order. And have you already signed a no contact order in the jail, Mr. Long?
Yes, Your Honor.
And you understand that under the terms of the no contact order, you're not to be at the same place at the same time as the protected person. Do you understand that?
Yes, Your Honor.
You're not to have any internet, social media, phone calls, email, text, any communication at all with the protected person. Do you understand that?
Understood.
The probable cause affidavit says two things that are a concern of mine, in that I just talked to you about a no contact order, and it's alleged in the probable cause affidavit that you walked downstairs while carrying a Ruger 5.56 AR-15 rifle and stated that you would kill someone. So do you live, I don't think this isn't an admission. I'm just trying to figure out in terms of a no contact order. If you bond out, do you live by the alleged victim?
No.
Okay. All right. So that takes care of number one. Number two, you are not allowed to possess any firearm of any type. Any. Not a rifle, not a shotgun, not a pistol, not a revolver, not a semi-automatic, not a machine gun. No guns at all, as a condition of your bond and as a condition of your no contact order. Do you understand that?
Yes, Your Honor.
Do you understand that you can't live at a place that has guns, because you'll then have access to those guns that would result in your bond being revoked? Do you understand that?
Yes, Your Honor.
All right. We're now going to address bond.
Thank you, Judge.
What if he had a boomerang? Would that count?
Mr. Long scored 3 on his IRS score, 3 moderate. He is currently not being supervised, and he has no failures to appear in the last 2 years and has no current holds. He does not have any other criminal history or any other convictions, Your Honor. However, he does have a pending domestic battery as a level 6 felony in the presence of a child pending out of Portage, Your Honor, which I'm assuming there is a no contact order that's been issued in that cause as well. Given the seriousness of this charge, Your Honor, he is alleged to have pointed an AR-15 type rifle at the victim, knowing he also has another no contact order pending out of another court, Your Honor, so he's not supposed to have any firearms of any kind. State would be requesting a $50,000 cash bond.
In terms of the filing of the cases, was that NCO issued in the domestic battery case before April 9th?
Yes, Your Honor, it was issued on March 20th of 26.
Ms. Traficante?
Your Honor, the pending charge in, I think it's DO6, the domestic battery, there have been multiple requests. The alleged victim in that case is his stepfather. This was a family dispute between my client and his stepfather that went awry. The stepfather had requested, and regardless who started the physical altercation, requested that no charges be filed. Went through the process of having that no contact order removed because they are going to be, my understanding, participating in family counseling. The current charge, Your Honor, it's my understanding that this took place at a mutual friend's house. It's my understanding there was a number of people that took place. I'm just getting into the case. The house nor the gun was my client's. So he doesn't have a violent criminal history. He is gainfully employed, Your Honor. He works at, he does maintenance at, and I can't think of I want to say it's Symphony. It's at a rehab there. It's at a rehab, Lincolnshire. That's where he works. He started working there about 4 months ago. He works full time. So prior to getting hired in there, they had, you know what I mean? He had maintenance checks. They also do work in an elderly population. My client is given wages at $17 an hour, even though he works full time. He nor his family would be able to come up with some sort of those type of monies. He's not a flight risk, and as I mentioned, the circumstances of his pending intimidation case is a result of a stepfather and stepson, mutual altercation. So the family is very hard trying to work towards removing that and kind of getting back on track within that household. So we would ask that he does have an initial hearing tomorrow on the domestic battery. I think that is set for 1 o'clock. And unfortunately, my thought that both of these matters were going to be set tomorrow at 1 o'clock. But that is set for 1 o'clock tomorrow. He has posted a $1,500, or his family had posted a $1,500 cash bond in that case. We would ask that this court join in with the $1,500 cash bond. If the court deems appropriate to do a higher level supervision while on trial, if the court is, concerned of or the state is concerned of any type of behavior that would make Mr. Long either a flight risk or a danger to the community, we would ask that there be a higher level of supervision. But a $50,000 cash bond is not realistic for this family, especially with what is happening now.
Okay. The Porter Superior Court 6 case, in all likelihood, tomorrow will be transferred to this court.
Right.
Because I will then be the judge of the current level 5 case in my court, and the DO6 case will be transferred in. So here's kind of my understanding. The defendant has signed a no contact order. And I'm just looking at this case, not at the other one at this point. And the defendant is presumed not guilty in both. The defendant is young. The defendant has virtually no criminal history to speak of. And it's probably also true that given the defendant's employment and given the length of the sentence in this case, if he received the maximum, would not make him a flight risk. But having said that, I can't think of anything more dangerous to another person than an AR-15 pointed at someone and saying that you're going to kill him. The only things that are missing is we don't know from this report, from the affidavit, whether or not
I hope he never meets the girl with the crowbar.
it was loaded, or whether or not the defendant pulled the trigger. If that was the case, then it would be a murder case. So I find that although the defendant is not a flight risk and that the defendant is presumed not guilty, that the defendant is dangerous to others, significantly dangerous to others, and I set bond right now in the amount of $50,000 cash in this case. A no contact order, which he signed, does nothing to protect bullets. Bullets go through paper, rock, paper, scissors. Bond is $50,000 cash. And having said that, Ms. Traficante, the DO6 case will be transferred to here tomorrow, and my staff will let Judge Tody's staff know that he's entitled to have an initial in the level 6, but we'll let Judge Tody's staff know the dates that I'm going to give you right now, so the level 6 case will be transferred here.
Judge Fish and Judge Clymer keep sending cases to Judge Tody. I can't get Judge Tody. He doesn't stream.
But bond is $50,000 cash at this point. The dates in the level 5 case, in this case, are now June 3rd at 10 o'clock for an omnibus change of plea hearing, July 15th at 10 o'clock for a final pretrial conference, and August 17th at 1 o'clock for jury selection in this case. And we'll let Judge Tody's court know those dates as well. But that case will be transferred here tomorrow, so I will have both the level 5 and the level 6. And at this point, bond is $50,000 cash, based on what we know right now. So I will see you all June 3rd at 10 o'clock.
Thank you, Your Honor.
Mr. Traficante.
So, he's setting cases in August. He's setting juries in August. That means very soon we're going to hear trials being set in September. That's how close we are to Christmas, guys. We're this close to Christmas already. Get ready. All right, we're going to end the stream with Judge Frost because I love Judge Frost. 2 different cases with Judge Frost. We're going to watch a mess, a dumpster fire. And then we're going to get an update on another case. But I'm going to talk to you about that quickly before that one starts. So we're up to date on where he is.
State would call Camilla Green.
Judge Frost does not want to show up today. He said nope. There we go.
Sorry about that.
No problem at all. Can you both see and hear me okay?
Yes.
And are you by chance Mr. Seekings and Miss Wardell?
Yes.
We are.
All right.
The Seeking and the Wardell.
Okay. This is case number 23 FA 1944, Lauren Wardell versus Brian Seekings. For the appearances today, I have each of the parties appearing together on Zoom video, each representing yourself today. And who do I have from the Child Support Agency?
Attorney Michelle Wagner from Dane County Child Support, representing the state of Wisconsin.
Thank you. And we're all on Zoom today. I've confirmed we can see and hear each other, and we're live streaming since we're doing this on Zoom. Today is the scheduling or a status conference to pick a date for a de novo trial. There was a issue that the commissioner heard, and then they drafted and signed an order on custody placement and support. I got that de novo request. Are you still looking for a new trial on that?
I didn't know she was picking the date. I thought this was the de novo.
Yeah, today was to make sure we set enough time aside and pick a day that works for you.
For the de novo.
Gotcha. Thanks.
What? Sorry. You're kidding me.
Okay.
Oh, sorry.
Yeah. So, ma'am, you still would like the de novo hearing?
Yes.
And
How long? Oh, go ahead, Attorney Wagner.
I would like to note that the order that was entered was a stipulation, and pursuant to 767.17 sub 1, the second to last sentence states the right to seek a de novo review does not apply to stipulations entered between the parties. So the state's a little bit unaware of what is being, de novoed in light of it was a stipulation, not a contested hearing.
Ma'am, any response on that?
I don't understand that. I'm not. The reason why I had to do this whole thing in the first place was to comply with child support because I was receiving funds. His dad was absent in his life during that time. And I was receiving funds for daycare. And then I lost daycare, which means I had to cut down on my hours for work. I had to find people to babysit my son. And so I had to comply with child support. And then I feel like I was just unjustified with everything, me taking care of my son and unfortunately father being absent. And, it's just, and then apparently I'm making more money. I was, I ended up that I owed him child support and I feel like everything was just really screwy.
When you were in front of Commissioner Coiroga, did you not agree to the terms of the order?
My anxiety took over. I was not as prepared as I would have liked to be. I was a bit late. They were talking before I even walked into the courtroom. I got to say 3 words and he shut me down and said that no. He said no. And just went along with everything and my anxiety just shot through the roof. And I don't think, unfortunately, that's just how I am.
So what do you believe was wrong in the order that should be changed? Are the two of you sharing 50-50 placement?
Yes. Currently, yes.
And then go ahead.
I guess I don't know. My son, I can receive daycare funds right now as well. And I just.
Believe it or not, I was able to cut the sound of the birds down at least in half of what it was. It's still there.
I think that we were talking about maybe just figuring out I don't know. I say my anxiety's kicking in. I just can't talk.
Well, feel free to take some deep breaths and we can wait a few minutes and then I'll be ready and waiting to hear from you when you're prepared.
Please don't face it at me.
Okay.
I'm just trying to understand, ma'am, what order you're looking to have changed so we can figure out how to discuss that and what would be the right way to proceed.
What she needed changed was they added up her wages wrong and it said that she was making more money than I am, and that was incorrect.
I believe I turned in pay stubs. If not, I will have to get those turned in, but I know I went into turn in some paperwork. And I just talked to a few people before the hearing that I was not able to complete all of the financial disclosures. And so she said that I would have to just discuss that with you, or I guess if this is not the de novo, I'm not sure how that proceeds, but that I would still have to get it turned in. But I found some extra papers that I did not see. And so I don't have any of my financial disclosures turned in. I don't work many hours since my son was not in daycare. I had to find help with having Sterling watched. And so I would get like 30 hours every 2 weeks.
Okay.
And so like I was making no money practically. And
Attorney Wagner, yep.
On her de novo request, all she checked was custody placement and half of health insurance. And that was on document 17, page 1. In the document 15 that Commissioner Schulenberg signed, it found her income, but it specifically states she was part-time. The court imputed full-time. So when they did the calculation, they specifically noted that's not what she's earning, but was what was imputed upon her. And I'm not sure if she's seeking a child support order or not. She's not required to, based on the calculation, is meeting guidelines due to the findings that the court did on the March 26 in 2026. So if she is wanting a change to that order, again, it wasn't noted on her de novo. I thought it was an issue with health insurance, but in custody placement.
Okay. Ma'am, do you recall agreeing to be imputed income at full time?
no, I did not know until I got the paperwork. When I got paperwork back in the mail and then I saw that, then I knew that was incorrect.
Mr. Seekings, what's your best recollection?
My best recollection is that they, all I can remember is that they were saying that, she was making more than me, and as I said before, that's incorrect.
I think, yeah, I think like I said, once I got shut down, I think my mind.
No, guys, that is not what happened. They imputed you to. The judge said, okay, you only make this much money, but you should really be making this much money. Most likely, it was full-time minimum wage. You should be making at least full-time minimum wage. And even though you're not, you can, so you should. Because you have to pay child support for the child. Or he doesn't have to pay as much if he's paying her. But she owed him for a little bit, he owes her. It's a mess. But neither of them understand that. They think that they took her income and had it at full-time when she only works part-time. But she can work full-time.
The body completely shut down. So I just.
Mr. Seekings, I'm asking more about, do you recall there being an agreement reached with the commissioner or in front of the commissioner?
Yes, I do, but I think, like Ms. Wardell said, things just got misinterpreted and there's some miscommunication there. And
do you believe she should be held to full-time earnings of 22 per hour?
No, I don't. She
22 per hour full time.
She only works part time because she doesn't have daycare assistants, and so no, I don't agree with that.
And what is the placement schedule for your child?
Right now, it's we're switching off every Sunday.
So it's yep. I get them 1 week. He gets them another week.
Yes.
Okay. And there's no daycare setup that you both use?
So as of right now, I was able to, now that I complied with child support, I was able to get into child care. I got the assistance, but I'm only granted 12 hours a week at this time because it went based off my stubs, which I said I was not able to work enough. So the 30 hours a week they granted me 12 hours a week for him. So he gets to go 2 days for 6 hours. And then, so that's another struggle is now that's how I have to base my work.
Okay.
I did get a form filled out by my job to say like, hey, she's actually going to be working this amount of hours, so that they can grant me more. But then that's another, it's really confusing for a 2-year-old to go to daycare 1 week and not go another. Go to daycare 1 week and not another.
No, it's not.
So, Mr. Seekings, what about you? You don't need daycare?
He's too old, Judge.
Not at the moment, no. But he would. Actually, no. I do. Yes. He needs to go. I do need daycare. Yes.
Okay. Well, why don't we set a hearing? I don't know if the right way to look at it is a de novo, because Attorney Wagner is correct. Normally, if you stipulate, you don't get to de novo a stipulated order.
Okay. I don't know. I don't understand any of this.
It's okay. It's okay.
I'm gonna have to do more research on, because this is my first child. This is my first court thing.
Please just, I know you're anxious and that's why you want to talk. I'm saying I'm going to give you a hearing. I'm going to hear it. I will issue a new order. I'm just making a little bit of a record in case this ever goes up on appeal, that I won't treat it as a de novo because you don't have the right to that, but I'll treat it either as a motion for relief from that stipulated order or as a motion to modify because it doesn't reflect actual circumstances for you. And both of you are in agreement that it isn't what either of you thinks the order should be. And ma'am, I can see you're very anxious today.
Sorry, my son's over there too, so I was looking at him.
That's fine, but I believe you when you say you got a little overwhelmed and you may have agreed to stuff without understanding what was going on. So I'm not going to hold that against you if you really weren't able to make a knowing agreement that day. So how long do you think we need for a hearing for you to bring your pay stubs, your financial disclosure for each of you, and to show me all of that so I can figure out what the actual child support should be?
3 weeks sounds good.
Yeah, I was going to say.
No, I'm sorry. I mean, do you need an hour? Do you need 2 hours?
Oh.
What time? Wait, what time do we have? 9:41. Can we do 3 hours just to be sure? Because I also have to take care of my son in the process. And 2 hours.
Okay. If all you're doing is telling me what your job is and how many hours you work, and neither of you really disputes the other person's employment, we probably could get that done in 1 hour. I don't think I would be hearing a lot of evidence. 3 hours would be if you're bringing in an expert to tell me that you could be working at a job, but you're not. And, okay. Do you want it in person or do you want to be by Zoom?
What do you want to do?
Zoom is fine. I think it makes me a little more comfortable.
Yeah, we can do Zoom.
Okay.
I'm not going to.
Attorney Wagner, does an hour by Zoom seem okay to you?
Yeah, it sounds fine as long as the parties file their financial disclosures with the court timely enough so that we can all see everything.
Yeah.
How do we file our stuff?
Here's what we're going to do. I think what I'm actually going to do is an income and expense statement. I don't think we need a financial disclosure statement, but with the notice of hearing that we're going to mail to each of you, I'm just going to send you a blank income and expense statement. There's a court form for that, but that way you'll have a paper copy directly from me. Fill that out and mail it back. You could drop it off, you could mail it, you could fax it, whatever you prefer. But I'm going to make you get it back to the court at least 7 days ahead of our hearing so that we can process it. And that way we'll all have it. You'll have to give each other a copy as well so that we can all be looking at the document during the hearing.
Okay.
Let me just make sure each of your addresses are okay on our end. Either mail it or drop it off. Either way, send it to the attention of Judge Frost on the 6th floor and then put your case number. It'll have a spot for it, but make sure you write it on the income and expense statement, okay?
Sounds good.
All right. And then we'll pick our day and time. Ashley, when could we get them in for an hour?
Double check.
We could do Friday, June 12th at 10 o'clock.
Okay.
You see and hear me okay?
Okay, so here's what happened in this case. Before, we already saw it. I think my minimum wage here is $7.25 as well, Bobby. It's crazy. What did they say? They said a person living in the 50s, if minimum wage was the same, like, oh gosh, minimum wage in the 50s would be like 60 some dollars an hour now if it grew like it should have. Minimum wage would be like way, it's just crazy. Minimum wage is crazy. Okay, so if you remember, this guy, he was supposed to pay child support. Now it's hard to remember that this is all about child support because it's so far in left field right now. But what Miss Cox's, his ex, or the mother, Flinger or something, that's his name, he's the dad. He did not pay child support and he was held in contempt of court. So he is taking Judge Frost's ruling to the appeals court to appeal that decision of holding him in contempt. So they still haven't got child support figured out, but now they also have this appeals going on, and the attorney, he's pro se, the attorney and him are arguing about how this appeals is going to happen. All right, so anyway, I don't want to say anymore. So Judge Frost gave a ruling. He didn't like it. This guy didn't like it. So he took it to the appeals court, and now Judge Frost has to decide some issues because this attorney wants more information for the appeal. And this guy thinks they don't need that more information. So the judge has to figure that out here. But it's all over child support.
Yes. Yes, Your Honor. Good morning.
Good morning.
Yes.
This is 2017 FA 2053, in re the marriage of Mia Cox and Michael Flieger for the appearances.
And I think they got divorced last time we saw this, I think. Right? They got the divorce done at least, maybe. I think. I don't know. I could be wrong.
Today, who do I have for Ms. Cox?
Good morning, Your Honor. Elizabeth Bach Van Horn appears for Mia Cox, and she also appears by Zoom video.
Thank you. And then I have Mr. Flieger appearing by Zoom video representing himself today. And we're all on Zoom. I've confirmed we can all see and hear each other, and we are live streaming since we're on Zoom today. We're here on the motion relating to some additional transcripts for the appeal that's going up. And then there was some discussion about whether I would hear another motion that's in front of Commissioner Asmus in a month on May 22nd. I said that I could if everyone wanted me to. I got the response from Attorney Bach Van Horn that you were not prepared and that there was not enough time or enough notice to be prepared for today. Is that still true?
Correct, Your Honor.
Okay, so we'll leave that with the commissioner, and I'll just deal with the transcript issue today. So I reviewed both of the motion and then the response filed to it, and I had one question outstanding, which is neither of the two really points me to, and I don't see anything in the statute explaining. Is there some standard I should be applying to this request? It's a bizarre statute in that it seems like it says once the appellant files their statement, the other side can say this additional.
If you get tipped, you don't make minimum wage. You make like two something an hour if you're a server that gets tips.
A set of transcripts should also be included, and that the other side is then either supposed to just do it or you can do it as the respondent. and that or the respondent can ask me to order the appellant to do it. It doesn't detail if or when I would ever deny that request. And I don't see any case law referenced in the notes under the statute section. I myself didn't perform a review of the case law to see if there's some standard I'm supposed to apply. Attorney Bach Van Horn, are you aware of any standard applicable to this issue?
No, Your Honor. It seems to me the statute is clear that if someone believes that transcripts are needed, that the appellant is required to get them. And since he hasn't obtained those transcripts thus far, that I need to obtain an order, as my client shouldn't have to pay for the transcripts herself.
Mr. Flieger, how about you? Have you found any standard of review that I'm supposed to apply here?
I'm not sure I can give you case law, but I believe the standard is necessity. And whether or not those transcripts are necessary for the appellate court to determine whether or not there's merit to the appeal, which is essentially all directed towards post-hearing activity. So if necessity is the standard, then I don't see any necessity to pour over 2 days worth of hearings plus an oral ruling when your orders were very thoroughly written and your reasoning and a citation of what you consider to be the facts of the case are present in your written orders.
From a practical standpoint, just having read a tremendous amount of case law in my professional career, I would be shocked if the Court of Appeals agreed with you on that an order without the underlying here.
I said it before, and I'm going to say it again. This judge knows more law than any other judge I know. Like, just watching him, he knows more about the law than any of the other judges that I see, and he quotes statutes like right off the top of his head. It's crazy.
Rating is enough for them to review anything. Other than if it's a glaring defect in a written order that they could identify strictly from that. But if any part of it is challenging any of the evidence that underlied the orders, I would think that they always want the actual record of what the evidence was. Otherwise, I'm pretty sure the case law says they're just going to affirm me because you didn't show them what was contrary in it.
So what they're saying is the attorney is saying he has to get the transcripts of the contempt hearing to them and to the appeals, to the Board of Appeals. And he's saying, no, they don't need that. They don't need those transcripts. So you have to pay to get transcripts. So he's like, they don't need it, so I don't have to provide that to them. And Judge Frost, in the nicest way, just said, I can't believe that they won't need the transcripts of this hearing. That doesn't make any sense at all, sir.
So as far as necessity goes, I really don't understand how the hearings that form the basis for the orders you're appealing, how could they possibly not be necessary for the Court of Appeals? If you were talking about a hearing on a different motion or a different order from years ago, I would understand, but you're talking about the transcripts of the actual oral ruling and the hearing itself that led to the oral ruling, and you're saying you don't think they're necessary, Mr. Flieger?
Right. So the statute specifically says necessary for prosecution of the appeal. So that's the standard I was relying on here. I think the respondent is arguing whether or not the record is complete, but I don't think the statute actually requires a complete record of everything that has transpired in this case going back to July or even prior to that, considering that it's going to be most of the respondent hasn't identified any passages or any particular arguments that were made in court that are relevant to the appeal, which is, to me, focused on the reversal of the contempt decision after the record was clarified by the child support agency. So I think the timeline is really important here. There were 2 hearings held in July and September, and then an oral ruling, and then you issued what I would characterize, and hopefully you might understand as a preliminary ruling, waiting for clarification of the arrears amount from the child support agency, and that's docket 318. Once that came in, and there was post-hearing correspondence, but there was new clarification of the record of the payments and the arrears owed at that point. And so through correspondence, then the decision was reversed to contempt. So that's one question that I have on appeal. The other then would be related more to the fee awards and the statutory limitations on how much can be awarded and whether or not attorney's fees can be included in remedial sanctions as opposed to, and then the statutory limit applied to that amount as opposed to it being applied to the amount actually that Ms. Cox is seeking reimbursement for. So to me, everything that I'm asking about happened well after we had our hearings, and I don't see any necessity of looking through the extensive transcript there for information that would help the appeals court decide, which I think is mainly issues of procedure and legal reasoning.
Any response, Attorney Bach-Van-Hoy?
Yes, thank you, Your Honor. Mr. Flieger is appealing your finding of remedial contempt and the imposition of attorney's fees and saying that the court record doesn't support a finding of willful disobedience. This is in the court's discretion. The finding of contempt rests on the trial court's factual findings regarding Mr. Flieger's ability to pay. And I do believe that these...
Yep. He had remedial contempt because he owed child support and didn't pay it. So he was held in contempt for that. And he had to pay the back child support as that's what the contempt was. He had to pay that.
Hearings shed light on the decisions that were made subsequently. Additionally, if the transcripts are not provided, case law states that the court will assume an absent transcript supports the circuit court's ruling. So if a transcript isn't provided, then that is contrary to Mr. Flieger's position regardless.
So why did you say anything? Why didn't you just shut your mouth? Were you legally, ethically, morally, did you have to say something? I don't think so. You could have just stayed quiet and then you would have won. I don't get why she said anything, but that's fine.
Not quite sure why we're here today, and that's Streff v. Town of Delafield, 190 West 2nd, 348. And remedial sanctions, per the statute 785.04, they specifically include payment of a sum sufficient to compensate a party for a loss or injury suffered by the party as a result of contempt of court. That includes attorney's fees. So really we're looking at how can the Court of Appeals accurately and adequately review the trial court's findings if they don't see what was the testimony, everything that was heard during.
I think it started with like $50 a month for 3 kids. And I think by the end I might have made it to $200 a month for 3 kids. And he was always in arrears. So after the kids had grown and finished high school and everything, he was still paying me.
Those 2 hearings, what was stated during the oral ruling, I do think that those are going to be important or the appeal, and Mr. Flieger should be required to obtain those.
Okay. Well, as I see it, I don't see any guidance about exactly how to interpret and apply 809.11 sub 5, which does allow a process for the respondent on the appeal to designate additional portions of transcript that the appellant chose not to designate. It says and I'm skipping into the middle of it, within 14 days after the filing of such a designation, the appellant shall file in the circuit court the statement required by sub 4B covering the other party's designation. That's a shall, meaning mandatory. And then it says in the next sentence, if the appellant fails or refuses to request the designated portions, the other party within 14 days of the appellant's failure or refusal may request the portions by filing a statement on transcript in the circuit court or move the circuit court for an order requiring the appellant to request the designated portions. It doesn't say anything about deciding whether or not, in fact, those transcripts should go to the Court of Appeals. It seems to say, based on the shall language in the second sentence and then the general tenor of the final sentence, that if a party designates transcript as being necessary, that it has to go to the Court of Appeals so that they can then decide what in fact is useful, necessary, important to their review and what isn't. I don't see anything in here as saying that the circuit court should make an initial determination of whether a transcript is useful, helpful, necessary to the Court of Appeals on their review, or that I should overrule a designation by the respondent. It really just says, once the respondent designates it, the appellant shall file it. And that if they fail or refuse, those are strong terms. They're not if they object or if they contest it, which would imply there's some right to do an objection or contest and have me decide. It just talks in terms of you have a duty and you either fail to do it by just missing it, or you refuse, meaning you insist on not doing what you're supposed to. And I think that's really the ordinary meaning that we all understand of the words fail and refuse, is that it shows either a inaction or a insistence on not doing what you're supposed to, but it implies that it needed to be done and it wasn't. So all of these terms tell me that I'm just supposed to order you to provide it if that's what's asked. So that's what I'm going to do. I'm going to grant the request and I'm going to order Mr. Flieger that for purposes of your appeal, you need to properly file the statement on transcript as to those portions designated by Ms. Cox. Any questions on that?
Yeah. So the portions of the transcript then that are being requested are the entire proceedings of July 10th and September 4th and September 12th. Is that my understanding? That's the whole transcript, not portions of it. Is that correct?
I believe so. Attorney Bach Van Horn, that's correct, isn't it?
That's correct, Your Honor. I don't know without seeing the transcripts which portions would be relevant, so we do need the whole transcript.
So yes, the whole thing from those 3 days.
Yes.
Any questions, Mr. Flieger?
No, Your Honor.
And I'm just going to
No,
look.
Your
I
Honor.
thought I saw that a proposed order was uploaded, but I want to try to find it.
Yes, Your Honor. It's document 358.
Okay. I just re-reviewed it and I'm going to sign that order because it covers what I was ordering today by specifying the dates for the 3 transcripts. So I will sign that. All right. Any questions on my order, Attorney Bach Van Horn?
No, thank you, Your Honor.
Attorney Flieger, I'm sorry, Mr. Flieger, any questions for you?
No, Your Honor, I'll contact the clerk of courts or the records office at the Dane County Courthouse and ask how this gets done. And I understand that there's a fee associated with it, and there's also other kinds of, and this would be sent as an electronic transcript, I assume, and not as a written printed transcript. That would be something that they would answer, I assume.
Correct. I believe everything is electronic now with the Court of Appeals, so it would, I believe, go electronically into our case, and then our case gets moved to the Court of Appeals electronically. I'm fairly certain about that.
Okay.
All right. But yeah, feel free to contact the clerk of court's office.
Your
Okay.
Honor, may I ask a question about the child support issue?
Sure.
Just given the trajectory of this this matter, I'm wondering if it would make sense and if you would be willing to
Hi, Val.
schedule for another day with you on that issue rather than be heard by Commissioner Asmus, so we can avoid the potential of a de novo and multiple hearings. I believe that was Mr. Flieger's request in his letter, but I wasn't quite sure.
Mr. Flieger, is that your preference as well, not to go through the commissioner?
I don't have any objection to going through the commissioner if that's the right way to go. However, it seemed that we've already discussed this issue in the prior hearing and that you have a lot of familiarity with what's going on. So, I thought for sort of rather than having the commissioner have to go and recreate the entire scenario with his own understanding, you seem to already have a basis that if you're willing to hear it, I'm good with that. Thank you.
How long do we think we need for that hearing?
Are you asking me?
Sure, let's start with you. That's your motion.
I have no idea. I think it's fairly straightforward.
Are you going to subpoena any witnesses from the school or elsewhere?
That wasn't my plan. I think the educational record is well, I think it's sufficient and to show us what's going on here. So,
Attorney Bach Van Horn, how long do you think we need?
Your Honor, I'd like to say it's straightforward, but it hasn't been. I would like to request 3 hours.
Do you plan to call witnesses other than the parties?
I guess that depends on if there's going to be an objection.
Oh, absolutely she does, Judge. Do you want to know why? She is going to sue him for attorney fees for all of this, every single minute of it. So yeah, she wants 3 hours.
To business records, which I'll be submitting in the next few weeks.
Submitting to the court or making available like certified?
Yes, I was going to provide certified business records. And I don't anticipate having a problem getting those. But I have concern, again, with the trajectory of this case that there might be objections, in which case I would need witnesses or more time to argue that the evidence is sufficient without witnesses.
Mr. Flieger, go ahead.
Question, I don't know what a business record is.
So I'm under the impression Attorney Bach Van Horn is referencing a hearsay statute, which normally excludes hearsay, which would be written records, statements by the school, or I assume it's the school, but maybe it's someone else, of what's going on. And without bringing a human in, that
Yes, Bill, so you should start taking notes.
there is an exception for certain business records that they can be exempted from our hearsay rule if they meet the requirements of that. Even then, usually you need to have some.
Yes, she's a lawyer.
I'd have to look at it because there may be one that applies to government that I'm not thinking of. I'm thinking of the usual business record rule, which still requires some identification of the document that it was a business record, that it was made in the ordinary course of business. There might be a different rule for some government ones because I know there are some hearsay exceptions for government documents. I would imagine that has to apply to school district records because that is a governmental unit, but that may be worth both of you discussing. So it's essentially, if you would agree that these records from the school are legitimate, authentic records that we don't need to bring someone from the records office at the school to identify them and explain, yes, these are legitimate copies of the true record that we contain. That would cut out the need for one or more witnesses. But if you question their authenticity, then you wouldn't have to agree to that. But then if it fell under some exception or exemption from the hearsay rule, it might still come in, whether or not you wish that a witness would talk about it. You mentioned that you weren't planning to call anyone from the school, so I'm a little curious what records you plan to produce, or if you're just going to have Ms. Cox testify and you testify. So I'm a little unclear as well exactly what's going to come in or how. Definitely you and Attorney Bach Van Horn could talk through some of that. It might short circuit the hearing and keep it well under 3 hours if we need to bring in a bunch of people from the school or a couple people or your daughter or who knows who else to get the information. Then I could see it taking more like 3 hours if we have to have a number of people come in. I am fine with hearing it. I agree, not to disparage or anything or no judgment based on it, but I would suspect that Commissioner Asmus would get de novo regardless which way he rules. So we could just save you all from having to go through one hearing if I just hear it, and I'm fine with that. So let's do that. Ashley, when could we fit them in for 3 hours?
My
It's
first
New
available would be
New York City.
Wednesday, June 17th at 1 o'clock.
I'm sorry, I'm not available that day.
Or it's
I will be
Wisconsin.
out of office the 17th through the 22nd.
I don't know who takes
We
more
could do 1
vacations.
o'clock on Monday,
Don't say that. Lawyers or, I mean, is there, except for the obvious, is there any other profession that takes more vacations than lawyers?
July 6th.
I can do that.
I can do that.
Mr. Flieger?
Getting there. Monday, July 6th. Is that it?
Yes, at 1
Correct.
o'clock.
What do I have on hold? I think I can make that work. Let's
Yeah,
just do
I mean,
that.
if you weren't paying child support, you say you got contempt, you don't have a job, so you're open that day, sir. you have nothing planned. Maybe doctors, maybe, yeah.
Will this be in person or by Zoom?
Do you have any preference? It doesn't make much difference to me.
I don't. I guess Zoom is easier for most folks, but
Yeah, I have something held on my calendar. I don't immediately recall what it is. I may be, I think that I may be out of town. And if I'm out of town, I can definitely do a Zoom call. So if we could do Zoom, that would be great. We don't have to pivot later.
Sure. Yeah, we'll do Zoom then. So I'll just say 10 days ahead of time, file any documents with the court that you want. And that way they'll get uploaded and everyone will have access to them. Ashley, do you want them in the exhibit queue or in the regular?
If they're going to be offered as exhibits in the exhibit queue, please.
So make sure you don't file them like a normal document. In the typical case record, look for the exhibit filing tab. Mr. Flieger, I'm mostly explaining that for you. Hopefully Attorney Bach Van Horn's pretty familiar with that. I don't recall if you've had to do that before,
He should win. He's doing a bang-up job.
Mr. Flieger.
Well, I actually did file long ago things as exhibits, and Commissioner Asmus essentially told us, I think at a hearing, that just file them as regular documents, that it was just simpler. So I think I had different instructions.
That's probably true that it's commissioners may have a different preference.
Yeah.
But we have, I have a different rule, which is if my clerk wants you to, you're going to use the exhibit Q. And that way it doesn't get into the record unless and until I admit it at trial. What that also means, though, is you're going to file them 10 days ahead of time. You have to email copies to the other side as well, because nobody will see them once they go in that exhibit queue. I think you can still see that you filed it, but I won't see it, and the other side can't access it until the hearing. So email it and file it in that exhibit queue.
That's helpful to know. Thank you.
Yeah, of course.
Can I ask one question about the business documents, please? And then this,
Sure.
I can make it brief. And so I don't anticipate there being any that I would have objections to sort of their authenticity or anything like that. I couldn't believe that anybody would forge documents or something like that, if that's what that means. One of the things that is true about the current situation is that the documents are protected under FERPA and so right now I do not have access to the school officials or other things. I guess I would just say for the record here, and this doesn't have to be answered here, but if Ms. Cox or would be who's indicated that she's willing to let me talk to our daughter's IEP coordinator or have him correspond with me if I have questions about what those documents say, if that could be available to me, that would, I think, help expedite that. And if there are any questions of what they imply or what they mean. But that, again, is probably actually our daughter's decision whether or not those can be released at this point under FERPA. But that would probably make things a lot easier, and we can avoid having people come in and
Yep. His daughter is 18.
say, yes, I wrote this.
That's my guess as well, is now that she's over 18, it probably is limited to who she tells the school they can talk to. I don't know. I'm just guessing on that.
I have a zip up sweater.
I'm just passing that along as if, let's, if we can all be on this. And it may not be any questions at all. But if the guy's name is David Morris, probably, who's going to write something, and if I was allowed to talk to him and ask any questions, that would be helpful. Just about what he writes, not about anything else.
Ms. Cox, did you want to?
I wanted to comment. It is Lily's decision, of course, but I have copied on all of the IEP reports and documents that I have received. I have not shared. I've shared everything with him that I have received regarding Lily's IEP and her entire educational plan. So he does have access to those things, and he has read it, I believe.
Yeah, I've got those.
Okay. Well, Mr. Flieger, if you feel like you need to collect more information, you can issue some forms of discovery to third parties, mainly try to subpoena people to come and provide records and do depositions. It is probably pretty predictable that if they're from the school, the first thing they're going to do is talk to their lawyer. Their lawyer is going to object. Maybe we'll move to quash a subpoena, and it may be a whole thing. I'm not sure. The same would be true with your daughter. You could arguably, because she's an adult, you could subpoena her and try to get records and deposition. That probably isn't great for her or your relationship, but it may be an option that you could think about. And we do have time if you need to go through that, since we're scheduling out into July.
Right. I mean, there's plenty of time. So, I mean, the main thing here is I want her to finish, and I think everybody does. And seeing that there's progress towards actually finishing is what the motion is all about. So, by July, she'll only be a couple months away from her, 2 or 3 months away from her 19th birthday. So, I understand the timings of things as well, but I'm just offering here, and for the record, if we can work together on this, that would be great.
Sure. Okay. Anything else before I let you all go today?
Not from me, Your Honor.
No, Your Honor. Thank you.
So he might try to call her. she's going to charge him. She is going to charge him for all the stuff that he's putting them through.
You're welcome. I hope you all have a good day.
Thank you.
All right, guys, that's what we got for today. Thank you so much for coming out. I really appreciate it. Hope you guys have a great day. And I will see you all again tomorrow. Bye, guys.
Well, I thought I'd write a happy song. I found a chat room where I belong. You don't know how much it means to me. With such a groove, I'm less lonely. Oh, Kathy's the creator. She's leading the way. At Court Vibes, we laugh and we stay. Her smile shines bright. She's got that grace. Come join the fun. It's a welcoming place. I can count on distraction from my pain, 'cause this creator takes you there and back again. Kathy is the heart here, always in stride. Her work is hard, but her joy she can't hide. Oh, Kathy's the creator, she's leading the way. At Court Vibes, we laugh and we stay. Her style is classy, she's always top shelf. Don't take my word, come and see for yourself. Her cases are new with a twist or two. I really like them, I believe you will too. A little lifeline passed along in rhyme. Why don't you join us? It's a guaranteed good time. Oh, Kathy's the creator, she's leading the way. At Court Vibes, we laugh and we stay. Her smile shines bright, she's got that grace. Come join the fun, it's a welcoming place. And so in conclusion, I'll wrap up this song. I hope I didn't miss anything that would be wrong. Hope I see you around. Don't stay on the shelf, join in the laughter. Come and see for yourself.